welcome back to the live stream. Surprise live stream for Sunday afternoon / evening / morning, midnight, wherever you are. And indeed, I have with me today our Alan Robert Shaw once again to discuss a number of issues with you. How are you doing today, Al?
I'm doing very well. I'm recovering from Falmouth Carnival.
Oh, would you like to tell our viewers what Falmouth Carnival is for those that are uninitiated?
No, I'll just let you wait for the CCTV to go up on Crime Watch. No, it was really good fun. It was really good fun. I was very disciplined actually. I did withdraw early because I had some work to do. But yeah, it's really nice, especially in these post-COVID times, to actually be allowed out to watch people, dressed up as pirates and fancy dress, and lots of crowds in the street, and lots of really great music. So yeah, had a wild old time.
Fantastic. Right, so a number of things to discuss in this video. So as the title and thumbnail suggests, lots of issues surrounding the issues of bankruptcy, punitive damages, insurance, default judgment. It's all going on in these couple of cases, including that trial, because, well, these issues span both of these trials in some sense or another, don't they, Al? So we'll be sort of covering both of the trials in a way, but all of the issues and yes, each of these issues are prevalent not just in these two cases, but in many other cases as well.
Absolutely.
So there we go.
I mean, one thing leads on to another. I mean, to answer the question, really, it's just to give way of background. In the recent Alex Jones defamation case, the Sandy Hook parents, the jury awarded damages, and they awarded two elements. They awarded $4.1 million worth of damages to the parents for their sort of emotional distress, harm, suffering. However, in the US, unlike generally here, they also have a concept called punitive damages. Over here, you can only recover damages for actual loss. They're compensatory, not punitive. But that's not the case in the state. They can say, and here's some extra damages just because of your conduct. And in that, they awarded $45.2 million.
It's just,
however,
yeah, it's just unheard of, isn't it? It's just, well, it's staggering, really, even to us. But go on.
But the issue is, and remember that from, yes, that other trial. I'm trying to channel Sabine Hofstadter there.
Indeed.
That other trial, there's a statutory cap in Texas, which is where the trial was, on punitive damages. And in the same way that immediately in that other trial, the judge said, oh, I've got to knock the $5 million punitive down to $350 because that's the cap. In Texas, the cap is $750,000. However, there are issues as to whether the cap applies. And this is proving to be rather complex because of the nature of how the damages came about. And also, it just goes to show, now we have tried to research this because the law says there is a statutory cap of £750,000 per claimant on punitive damages. However, there is one statute that says this cap only applies in the following circumstances and lists three types of claim, which are sort of malpractice type claims, that sort of thing, medical malpractice, etc. But there's also another statute that says the punitive cap does not apply. So there's one saying the punitive cap does apply in these specific circumstances. There's another one saying the punitive cap does not apply in these specific circumstances. Now, that's any sort of criminal conduct. So any tort that effectively arises on the back of could be called criminal conduct. So if you sued somebody for assault, if you sued somebody for fraud, that sort of thing. Within that, I can't see anything that sort of matches up as a criminal equivalent of defamation. However, there's also says that it doesn't apply where a tort is committed maliciously or intentionally. And we're back to this thing again now. And this is what crops up in this other trial and will crop up if there's an insolvency, and also it relates to the insurance claims. The question is, was Alex Jones found to have acted with intent or recklessness, the test for malice? And the problem here is there wasn't a trial. Because of the issues around non-disclosure in the discovery process, judgment in default was entered, and we have a copy of the order, and it literally just says judgment shall be entered for the claimants. Now, what does that mean? Does that judgment mean Alex Jones was found to, like I say, to be acting intentionally or recklessly?
Because this is rare, isn't it? It's not, and just to sort of put the brakes on a moment. So, default judgment, just to broadly explain the concept. Default judgment is when you've not responded to a claim, you've not really answered the claim, and you just get the judgment. There hasn't been a trial. There's no finding of fact. And so if there's no finding of fact, how can you find intent, malice, and so on and so forth? You just you get what you're asking for, which is a judgment for what you've asked for, but without any more.
Yeah, so it just purely went on to the quantum stage. In other words, you have effectively been found, quotes, guilty, albeit it's a civil case. How much? So now we just need to decide how much you have to pay,
and that's quantum. Again, I'm going to jump in and sort of like I'm not being condescending to anybody. I absolutely promise, but there's all sorts of phrases that Al and me and many other lawyers will use that we all understand. Quantum. It's just an amount. It's just a value. So you'll talk about what we call liability, who's responsible, and if you establish who is responsible, then we go on to quantum. So okay, this party is responsible for how much, and that's quantum. Carry on.
Yeah, no, and that's the issue. You see, so they're just having the quantum stage, but the issue is from the judge's order, what was Alex Jones found to have done? Now, when the parties pleaded their case, there's this rather weird thing that if malice is an issue in defamation in England and Wales, certainly, when you put the particulars of claim in, you don't raise the issue of malice in the particulars of claim. Mm-hmm. You leave it for the defence to come back. You know, when the defendant files their defence, they will say, aha, but if this was said, it was said on occasional qualified privilege, which means you have to show that malice was applicable. And then you file a document called a reply, which is a reply to a defence. You don't always have to do that, but in certain defamation cases you do. And you say, yes, well, we defeat your defence because we can show malice. So even if we get hold of the particulars of claim, and the wonderful Andrea Burkhart has been looking into that for us, mm-hmm. It might not say in there what they were seeking to prove. They will probably just said, you know, we seek to prove that Alex Jones said something untrue about us and we caused loss. But it's merely the test is said something untrue, because of course, you can actually, weird as it sounds, you can defame somebody accidentally. You don't need any element, to use another Latin phrase, mens rea. In other words, a state of mind saying, I intend to do this, or I don't care if I do this.
No, it's just an action, isn't it?
Yeah. The classic example is there's a case about somebody called Artemus Jones. Back in the 30s, somebody wrote a satirical piece about somebody called Artemus Jones going on holiday and perhaps having a little bit of a dalliance with some ladies, which was considered to be, not really appropriate at the time. And that was just a fictional account. Unfortunately, there was a real Artemus Jones, and he was a lawyer, and he sued for defamation and said, everybody thinks that's me.
Yeah.
And he won the case, and that's completely accidental.
That's how it works, isn't it? You make a statement, if it's defamatory, causes loss, so on and so on and so on. It's set. It's just like we have what we call a strict liability offence, which is you don't need to have any intention. So most crimes, not all, certainly not all, but most crimes need two parts: the intention to do something and the act of actually doing it. And then there's an overlap between different things. So you can have a much more serious one. So someone, let's say someone dies from the injuries, you didn't intend to kill them, but you certainly intended to cause them some serious harm. Then the law will say, well, that's not really any different. You intended to cause them some serious harm. The fact they died and you didn't intend it doesn't really matter. You intended the serious harm. And then there's various, like we call unlawful act, manslaughter, which is where someone's died just because you've done something that is unlawful, illegal, a crime of some sort, which could be not even a form of harm type crime. It could, as long as it's an unlawful act. You've done something, let's say criminal damage. Criminal damage is obviously a criminal act. It's an unlawful act. You do some criminal damage, someone somehow gets seriously hurt by it, ultimately ends up dying. You could have a case of unlawful act manslaughter there because someone died as a result of your unlawful act. This is a way that all of these interweave. And so circling back, as Al just said, there is no intent necessary. Just pick up on this comment here just so I can clear it from the screen. But how can the judge just give a default order? Well, that's if someone doesn't respond to the claim at all, the court says, well, you didn't answer it, so I'm going to give the party who's claiming what they want. So certainly in England and Wales, the way that works is there's a set timeline within which you must respond. And in our rules, if you don't deny or deal with an allegation, you're deemed to accept it within the rules. And that goes for just bare denial as well. If you just barely deny a claim, say, no, don't agree. So for some, let's say, I'm being very careful with my words here, but sort of lesser experienced lawyers, they might just respond and say, we deny that. But that's not enough. You've got to put forward a positive case. And so if you fail to deal with an allegation properly, you're deemed to accept it. But within these rules, if you don't respond at all with the defense or acknowledge the service, there's more rules about it. But if you don't acknowledge it at all, then the party making the claim in that first instance can just request judgment. It's not even an application or a motion, as it would be known in the States, but there's no application necessary. The court just says, well, they didn't deal with it. We're going to give judgment. I had one such case where the judge said, well, this was an application for judgment. There was a lot more involved. And the judge said, well, what's the defendant's view on all of this? And I just turned to an empty chair and said, well, it's not even here. So that sort of sums it up. I see a super chat coming in. Let me just pick that up as well. I haven't read these. I just bring them on screen. But that's my legal disclaimer, by the way. But thank you for your generous super chat, Lady Decade. I've been told I should try to contact you. But is that your... I think, is yours the video... I haven't actually seen it. I think this was I'll bring you up to speed. Al doesn't know about this. I don't think we've discussed this, but there was some video. Someone's claiming copyright of something. I haven't seen the video. Yes, thank you for contacting me. Al and I are looking for cases that we can discuss, analyze, and digest. We did one for a fellow YouTuber, Ashley Neal, which. Secret McSquirrel, if you can possibly dig out, I know how fantastic you are, if you can possibly dig out the link to the Ashley Neal video, you can dump that in the chat for Lady Decade to take a look at. And that's the kind of structure that we're doing. We're looking at what someone is claiming and dissecting it for about an hour. This takes when we bounce our thoughts back and forth between us. And I think that might be good for you, because without commenting on yours, because I haven't seen it, what we get a lot of, I get a lot of, because one of my practice areas is copyright and trademark and passing off and because that's part of my practice, because I was in business for many years and necessarily deal with copyright and trademarks and all that sort of stuff. BlackBeltBarrister is trademarked, by the way, for anyone who's wondering. We get a lot of letters come in say, you've used our photograph, we want £300, £400, £500. My usual response to that is, well, it's not really infringing copyright, because it was either incidentally included and it's not really copyright infringement, or it was used in any one of the number of permitted uses for copyright. That's the usual response. And I say usual because most of the claims are bogus. But I understand they can upset. And I did watch at least a portion of your video. If I am talking to the right person, I think I am. I watched a portion of the video, and I can understand how a lot of people can get very, very upset about it. Thank you, Secret McSquirrel. So that link to the Ashley Neal video is now in the chat box. So yes, my first suggestion to you is don't, it's probably too late, but don't absolutely panic and get into a fit state over it. There is always something you can do about it, even if that is, I'm sorry, we won't do it again or whatever. But very often it's a case of there's no claim here. So if you could direct us to the actual content and the actual photograph and the actual letter anonymously, we will not publish this on this video. We will not name the law firm. We're not out to call anybody out, any law firm out, because, well, for one, we're not allowed to do that. It'd be against our rules. But more importantly, it would be unfair, be unprofessional. We wouldn't do it. But we're happy to talk about it. I'm speaking without having even spoken to Al about it. I'm sure Al, you agree, or you're free to disagree, of course. But
no, I agree, because like I say, we were looking for opportunity, because I quite like the fact of getting sort of effectively instructions live on air, because we were saying before about to show how it really happens, the spontaneity of it all. But yeah, I mean, these are relevant issues. But the whole point of us doing this, and there is this wider issue now because of all the commentary on that trial as to why people do it. And to be honest, we genuinely do it because we'd like to demystify the law and explain to people. And lawyers generally do that. There is this thing that there's this idea that some professions operate what they call they call it shamanistic language, where it's very in-group technical language, and we do that, and that is alienating. That's why Dan always explains, whenever I lapse into Latin. But the whole point is that I don't think we were deliberately these days trying to exclude people from access to justice, or not quite as protectionism as that. So this gives us an opportunity, and even these big high-profile celebrity cases. They have issues in them that apply to everybody else. So, judgment in default, as we discussed it. And to get back to that, the reason Alex Jones's case was struck out was it wasn't just that they did actually defend it, but they failed to comply with directions, because you've got all this discovery and stuff. And when you go to court, one of the first hearings is a directions hearing, and a judge says, here's the timetable, and here's what you've got to do. And I've mentioned before about how I've managed to lose unopposed hearings, even when the other side have consented, and people are going, how have you done that? That was actually trying to vary directions. We'd had a timetable, and both sides agreed, actually, we could do with a little bit more time to do this, this, and this. So we stuck an application saying, hi, Judge, can we just move that back a couple of weeks? The other side are happy with that. Here's a consent order. And the judge took the perhaps not unreasonable view that like directions were a matter for them and not us just to totally disregard and do our own. And that's why I managed to lose an unopposed consensual hearing. But what happened in the Jones case is the judge said, right, if you do not comply with this, I'll strike out your defence. I will bar you from taking any further part in the proceedings, and I'll just enter judgment in default. And that's what she did. And you have to be very careful to bring it back to, what's useful for English and Welsh viewers especially. Yeah. Some of these timetables they set, some courts operate automatic strikeout. It's a pilot scheme at the moment, where if you miss a deadline, the other side don't even have to apply to court. The computer just goes, ping, they missed the deadline, and when you claim or your defence, it gets struck out, and judgment is entered for the other side. I mean, like I say, and then you've got to go and apply to set aside a default judgment, which is a nightmare.
Yeah. And sometimes get them reinstated because fees weren't paid properly and things like that. But the thing is, there is literally, it's happened so often and caused so much wasted time, because if a court ever needs and has to look at these kind of things, the court is likely to say, well, what was the cause of all this? Was it a party's fault? Were they being deliberately or just careless about the whole thing? Or was it a simple mistake made by, let's say, the lawyer? Because believe it or not, solicitors often deal with so many cases, they just don't pay the fee on time. And because they don't pay the fee on time, the claim's struck out. That's quite catastrophic. But the court will usually say, well, we'll make them pay certain costs and whatever, but reinstate the claim is usually what happens. But I've been in cases where this has been defended, and we've had a hearing, and another barrister's turned up, and I kid you not, I didn't say a word in that hearing. I mean, I was there to say, we'd like the claim reinstated, please, because the solicitors just forgot to pay the fee. That was it. And there's literally a bit in the white book that says the defendant should not take advantage of an administrative error by the solicitors and da-da-da-da. And so I had not to say a word. Even I would normally introduce the case. I represent the claimant, da-da-da. Didn't have to say any of that. We walked in. The judge just said, right. He pointed at the defendant counsel. I don't know why you're here. You shouldn't be here. You shouldn't be defending this request. You should have acceded to this request. The claim's reinstated. No one gets any costs. Get out. And that was it. It's over and done in 2 minutes. But it just highlights the need to follow the rules and to cooperate. This is court time is supposed to, I've said this a number of times just recently, court time is supposed to be a last resort, not just I'm going to take you to court, and it's not meant to be used as a weapon. But here we are.
Exactly. Yeah. I mean, but the one thing we've said before, though, is when we were talking about the accidental disclosure of privileged material, English court expect the lawyers to sort it out themselves and not be coming to court with applications on this. And it's quite common that if somebody files an application for a judgment to set aside a judgment in default, there's a 3-part test. You've got to have acted very quickly when you find out there is a judgment. You've got to have had a good reason for being in default, and also you have to have a decent defence. And that's where the extra hurdle comes in, because if you get a defence in time, it can be rubbish, but at least it'll get you further down the line. Whereas if you're saying I want a judgment in default set aside, the judge will say, well, let's have a look at your defence and see if it's got any legs. But you can usually tell if somebody files an application for a judgment default, you can usually look at it and go, you know what, the judge is going to let that one through, so we won't even bother contesting it. Will say, okay, we agree for the judgment to be set aside. This is why it's usually easier to go up against people who are represented. When people, quote, lawyer up, you might think, oh no, you've got an advantage going against a litigant in person. You don't actually in litigation. And I've known people going against litigants in person have said, we will pay you a couple of £1,000 to pick the lawyer of your choice to advise you on your claim, because they will tell you it's rubbish and it's not got legs. And that can be worth doing. It's like, look, we can see why you think you've got a good claim. You haven't, but we don't expect you to take our word for it, obviously. But look, you go find a lawyer you trust, ask them for advice, we'll pick the tab up.
Indeed. Just as a very, very brief tangent, I've noticed that there are a few comments in the chat about Alex Belfield. I haven't commented for a very good reason, because, not only has the judge said no comments in the case while it's still live, and it's still live until the sentencing, of course. That's the reason. I mean, other than adding to what he's already said, which was for guilty, for not guilty, I can't really say anymore. So that's it. He's made that announcement. That's as it is. I cannot pass any comment. If I did, I would be I'd be compromising the whole process of the case, which is the same reason I didn't comment during the trial. So just to explain that, not avoiding the issue, but I am, but because the judge has said so. So there we are. Generally, we can't comment on live cases that are active in court if it were to prejudice the case in some form or another. We are allowed to express some kind of opinion, but it's a very, very delicate matter. I mean, in fact, at some point we're absolutely forbidden from doing so. Now we're just told that you can, but insert number of rules to follow, which just makes it not really worth commenting on. So there it is. I see Uncivil Law in the chat. Welcome. If you haven't already popped over to Uncivil Law, you absolutely should do. Secret Squirrel, if you could dump the link in the chat box. I keep saying description, in the chat box. I'd be very grateful. Uncivil Law, go check him out.
Uncivil Law raises, that's really good. It's all fair, because they raised the next thing I wanted to talk about.
Absolutely. Here it is.
Hey, thank you, Uncivil Law. That's perfect timing. Because, to follow on from what we're saying, let's say that they decide the statutory cap doesn't apply for whatever reasons. Like I say, that could be difficult because there's no way of knowing from the judge's order as to whether or not there was any finding of intent or malice, even if that's part of the test. So that's going to be a problem. But there is also the thing that the courts look at what we call the ratio, which is how much larger or smaller are the punitive damages compared to the compensatory damages. Because let's say you win $1 million for your hurt and distress, and say, right, punitive damages, how much can we award? Well, the Supreme Court of the United States relatively recently said, we approve of a 1-to-1 ratio. So that was a case where there was like 100 million damages or something, and there was 100 million punitive damages. So 1-to-1 is probably, fair and reasonable. Although they did say this might be something we should leave to individual states' courts to decide. And this Supreme Court seems very keen on the states' rights idea, so they might not interfere. So it'd be down to the Texas courts to decide what extent the cap is. Now, what's the ratio? Now, this ratio is effectively 10-to-1, which I think a lot of people are surprised about. We're looking at the history of this to see if there's any other, similar awards that we can get some guidance on, and nobody's so far found any in Texas that we're aware of. But there is a chance that the court would step in and say, look, we understand what you're doing, but there has to be some sort of proportionality here. I mean, I certainly think that the Texas court would uphold, 1-to-1. I think they'd say, okay, you can have the $4 million for the compensatory and $4 million, say, for the punitive damages. They might even be willing to go a little bit higher than that. 10-to-1, though, I mean, you never know. You never know. It depends what view they take. I mean, they might just take we're not going to interfere with the jury, because, of course, there is this idea in Texas that they're very, hey, we leave it to 12 good men and true. It's a relatively non-interventionist sort of state. It's all that freedom and independence, and we know best. It's the Texas spirit, So it might well be that plays to the claimant's advantage. But to get back to the answer to our question, will Alex have to cop up the 45 million? The answer seems to be we don't know, and he's certainly got grounds for arguing that he doesn't have to, and I suspect we'll see those grounds argued. But again, and then to get onto other things, this is the problem with the default judgment of knowing exactly what people have found. This crops up with the insolvency thing. If in that other trial, the defendant declared insolvency, there's this thing about, are judgment debts extinguishable in bankruptcy? And again, it comes back to this, not if they arise from malice. But in insolvency, malice is intentional. In defamation, malice can be intentional or reckless. And the jury form doesn't distinguish between the two. It would be so much easier if it had a form saying, did you find that the defendant acted maliciously? Yes. Yeah. If you did find yes, was this intentionally or reckless? So many problems. Because again,
it would make life easier, wouldn't it?
It's cropped up in the insurance cases without getting into details.
No. Let's get details of the generality of the principles. Right. I think because those permeate throughout lots and lots of different cases. For example, we have
It's relevant to people at home, you see, because as we always say, check your credit cards, check your bank account, check your home insurance. Do you have legal expenses insurance?
Yeah.
Because Amber did, and initially a firm called NY Marine stepped in, and they insured her for this case. Now, they allowed certain lawyers to be instructed, and something happened. There was a bit of a fallout or something, and both the lawyers and the insurers parted company from Amber Heard. But by that stage, they'd forked out over $1 million. Then a company called Travelers took over, and we know from the pleadings that they forked out at least $7 million so far, and they appear to be funding the appeal. But in the trial, somebody from Travelers was actually sat in court every day. And you will get insurers sort of going, because they've got a vested interest in, where their money's going and stuff, and not racking up costs, because they, especially in the American rules where they're not going to recover the cost. Over here, you can get legal insurance, but the insurers can recover their premium and their cost from the other side if you win.
Yeah. And that's why they need to be noted on mortgages and things like that as well. So their interest needs to be noted, and that can be fatal to a claim. And you can get what we refer to, at least, which there's either the same or an equivalent term internationally, but we have a term of fundamental dishonesty. Now, this can be severe, far more severe than people tend to think of it. So if you make an insurance, you might find we've only had to make sort of one or maybe two insurance claims in many years, but you'll find that if ever you make an insurance claim, they will ask you, they almost grill you as though you're in court, to ask you lots and lots of different questions, backwards, forwards, ask the same question in different ways, and telling the story again and again to see whether it's the same all the way through each time. Because if there's a hint that it's untrue, they'll tell you that they think it's untrue, and they won't pay out on the claim. But likewise, when you get to court, that's partly because they want to know that your claim for the other side is going to stand up to that kind of scrutiny. Because if you're found to, frankly, have lied, made up the claim, you can get this marker of fundamental dishonesty. Now, that will only ever be noticeable when when you go for a new insurance policy, and they ask what seems like a very benign question to begin with: have you ever been declined an insurance policy? Have you ever had an insurance policy cancelled on you? And most people just no, because, and not really knowing why they're asking the question. That's the reason. So if you've ever had one cancelled or declined and this sort of stuff, it's because you've got this one, likely because you've got a marker of fundamental dishonesty, and that means you won't get the insurance policy, and they just won't give you one. And that can have knock-on effects. If it's for driving, you must have an insurance policy, so you can't drive otherwise. And so then there are specialist insurance companies that if you've been declined elsewhere, you can come to us. But of course, they'll charge you 3 times the premium, and so on and go around in circles. But the best, not advice, guidance, you understand, for reasons we've explained in another video. But guidance, the premium, well, it's not really, well, it is a premium. The additional payment premium, whatever you want to call it, for the legal insurance on any policy is the best money you'll ever spend. It'll be £20 or £30, or I think the most I've seen is like £100 for all of the bolt-on legal fee insurance to, they cover family disputes, personal injury disputes, and like most people go to a no-win, no-fee personal injury lawyer. But if you've got it on your home premium, you don't need to, because the no-win, no-fee is going to take a slice of your damages. Your own home insurance won't if it's on your premium, on your policy. So, yeah, this is the best value legal service you'll ever get by getting it through your insurance company, because they'll claim it from the other side if they think you've got a case, but they'll grill you first to make sure that you're right and they believe you.
And that you've got a decent case. Because I used to write advice to insurers, and they always want to know, is this worth a punt? But that was with what we call after the event insurance, which is slightly different because you're not entitled to that as of right, whereas before the event insurance, which is like the credit card, bank account stuff, they have to pay up. But anyway, so we have the other. So basically, NY Marine go out of the picture and they say, go away. Amber Heard then uses Travellers, and they appoint a new legal team, including the lovely Elaine, and they fund it to $7 million. Now, what has happened is, post-trial, there are 2 claims going on. First of all, NY Marine want a declaration to say, we don't have to fund this anymore. It's not breach of contract. We don't have to pay any more from this. That's their separate claim. NY Marine are suing, Travellers are suing NY Marine saying, we've paid out $7+ billion for this claim. We want you to chip in half of that. And there was a going, no. Now that looks like it's about to settle, and we're not quite sure what's going on there. But they've sued for that. Now, here's the interesting thing. People have said, why are Travellers still insuring the appeal? Because there's nothing they can get out of it. They can't get any more money back. And if they've taken the view this is a no-hoper, which a lot of people have taken, why are they doing it? The answer to that is very simple. Let's assume they said, right, we're not going to fund you anymore. And Amber Heard lost and then sued for breach of contract, saying you weren't allowed to stop insuring me. They're looking on the receiving end of a $110.3 million negligence breach of contract claim, because they can claim, well, I wouldn't have had to pay the 10.3 and I'd have won my $100 million counterclaim. Now, even if they think that's a frivolous nonsense lawsuit, they don't want to be on the receiving end of that. So for the sake of fronting a little bit more money to fund the appeal, they avoid that. But notice that's why NY Marine have gone off specifically saying, we want a declaration from the court. That's all they want the court. I understand. Sorry, Siri, I wanted to you. She's very good on these things. Yeah, they just want a declaration from the court saying, we don't have to fund her any further, because they want to avoid the breach of contract claim as well. But the interesting thing is, could Travellers get off of paying, or could NY Marine get off paying, claw their money back? Because the policy says this doesn't cover. Now, the trouble is we've looked at the policy, and it's a really circular argument. There is a very strong argument. It doesn't cover intentional harm, torts arising from intentional acts. And then you get into this, she was found to have acted with malice. I'm not so sure about that, because I just think it's really bad drafting in the insurance policy. But it's got a circular definition. And when people are saying it doesn't cover intentional acts, there's certainly clauses in there that suggest that, but then it specifically does cover things like malicious prosecution, which is, despite the name, can only be intentionally. So it's very confusing. But again, we get into this, if they're saying we don't have to, your insurance policy is void because we only cover non-intentional acts and you were found to have acted with intentional harm because you were found to have acted with malice, we've got this thing back with the jury where they say, well, no, that's not been found. So it'd be the same row they would be having in the insolvency court about, does the decision of the jury mean that it was intentional or reckless? And is there any way of establishing that without actually having the trial again? And that's what we were saying about how all these issues tie back into each other.
They all tie back together. Just to pick up on this super chat, and I'll deal with this super chat, and then I'm going to ask you for a bit of patience to thank my sponsor, that helps us to keep going on these streams and videos. But let me deal with this super chat first. So thank you, Gillian, for this super chat. I think on behalf of no, it's on behalf of yourself. Question: if you don't inform the company of a criminal conviction, I presume you mean what happens? Well, it's an interesting question because there's a full disclosure obligation with insurance policies. It changed, at least in England and Wales, not too long ago, whereby it used to be the case that you have to tell the insurance company absolutely everything that you think they possibly would want to know. Otherwise, they can cancel your policy. But in true consumer law fashion, those that write the law said that's a bit harsh. We think the insurance company should ask the questions, and then you should be honest about what you need to tell them. So it was changed very slightly to say that, well, if the insurance company asks you, you have to be honest. And if you're not honest, then they are entitled to cancel the policy and so on and so forth, or refuse to pay out on any claim, which it might only ever come to light when you make a claim, because they might not bother checking otherwise. They might just trust you. But when it comes to the point of a claim, then, believe it or not, insurance companies do try to get out of paying out on insurance claims. You might think that that's wrong, but that, if you're in the insurance business, I'm sure you'd probably do the same. But if everything is to order, they will pay out. In my experience, they will pay out. Not like my experience, my client's experience, obviously. If everything's in order, they'll generally pay out. However, the law also says that there are certain things that, well, whether they ask you the question or not, you really should be telling them about it. And convictions is one of them. And so I think you can assume that if it's fair to say they would want to know, and they probably decline you if they knew about a severe criminal conviction, let's say dangerous driving or death by dangerous driving or whatever, and you didn't tell them and they just forgot to ask, that you should have told them. That's one of those cases. So not always, but usually if you fail to tell them about that, it could be fatal to a claim. So I hope that was your question, and I hope that answered your question. And before Al bursts into what he's about to say next, please allow me and afford me the patience to thank my sponsor, NordVPN, that allows us to keep growing this channel. Bear with me. This is actually a pre-recorded video. It's not very long. Please stay with me. And just a brief interruption, as I said earlier, part of this video is sponsored by NordVPN. So thank you for giving me just a few moments to thank my sponsor to help to support me and this channel so that I can continue helping you to understand law. As I've said previously, I would never recommend anything to you that I don't use myself. I use NordVPN, and I have done for over 2 years now, and I've paid for that with my own funds. It hasn't been free. I've paid for it long before Nord sponsored my channel. Just recently, you'll remember videos when I went on holiday, and in a holiday let and going to cafes and restaurants, you can be a little bit suspicious of the Wi-Fi that you're connecting to, and you might want to make sure that your devices are safe so that when you do internet banking or even your emails and any other kind of file transfer, that your data is safe and that your devices are safe. So I was very reassured to use NordVPN to keep my data safe and keep my machine safe whilst I was on holiday, connecting to different Wi-Fis and so on and so forth. But also in my line of work, I get sent lots of different files and I have to check lots of different websites, and it's really important to me and the integrity of both my own practice and my law firm that Everything is scanned and checked for malware, which is a new feature that Nord provides to make sure that your devices are safe and protected from threats. And yet another feature that I've had to use time and time again, and just recently that Nord provides, is to change virtually my device location so that I can watch material that is only available in the United States, because I need to access those videos to produce these videos to bring you on this channel, which I would not be able to do if I couldn't virtually change the location of my laptop to the United States. For example, with videos to do with this Amber Heard trial, so that I can change my location so that I can bring you comments on those videos because they were only available in the United States. And as a creator, Nord provide me with a unique link which I'll put on screen right now, and you'll find in the description below, for a fantastic discount that you can get on sign up as a viewer of my channel here using this link. And finally, this software works on all of your devices. I use it on my phone, I use it on my laptop, I use it on my iPad. It keeps all of them secure, and it keeps me secure in the knowledge that my devices and my systems are safe. So thank you for the time for allowing me to thank my sponsor and provide this message to you. And now back to the video. As I said, thank you very much for allowing me to thank my sponsor that helps us to keep this channel going. Al, you were bursting to say something just now.
Because I had a legitimate opportunity to use some Latin.
Go for it.
There's a doctrine in insurance called uber fideles, or sometimes fideres, which means of utmost good faith, and basically says, unlike most contracts, which is, caveat emptor, more Latin, buyer beware.
Buyer beware.
Generally, normally in a contract, say for instance, Dan wants to buy my car, and he says, I'd like to buy your car, please. Well, there you go. Say I know that if he says to me, is anything wrong with it? I might have to say, say no. So, is anything likely wrong with it? Well, I have got a dodgy head gasket. I think that's about to go. I would have to tell him if he asks me. If he doesn't ask me, it's tough. I don't have to tell him. If it's just, as long as I'm not, he's dealing as a consumer, all that dealing as a consumer stuff. If it's just Dan buying it off me. If, however, he doesn't say anything, I could just keep stum about it. But let's say Dan wanted to insure my car against breakdown, and he was offering an insurance policy. Then even if he didn't ask, I would have to say, oh, by the way, I think that head gasket might go. So the test is, you must raise anything that a reasonable person would think might change the insurance company's mind, or at least make them consider, the element of risk. You have to volunteer that information. You can't keep quiet. Although, as Dan says, that has changed a bit now, because they're saying, especially in a consumer market, you can't expect people just want to fill a form out. So they're pretty much saying to insurance companies, anything you want to be sure about, you should raise yourself and ask the question. Although, sometimes you will see a catch-all question. Is there any other information you think may be relevant to this?
Yeah.
And that's
although putting my consumer lawyer head on, that wouldn't cut it, really, because a judge would say, well, how does the consumer know what you want to know? It's just, it wouldn't cut it. There's so many. This is why I love contract law, although it might, on the surface it sounds boring and dry. I love contract law. I love consumer law because it governs how people interact and set up these contracts with each other. Because this old phrase, if it's not written down, it didn't happen. Well, that's nonsense. If it's not written down, you can't rely on it. Well, you can. I've had cases where it's just been an oral contract. All of the terms have been agreed verbally in a conversation. There's just a few rules about what you have to show. It's who said what, the exact words spoken, when and where, oddly enough, the people were. And I suppose that's because it's more credible if you can say where they were, because the other side's got an opportunity to say, well, I wasn't there. I was in Spain or whatever. But anyway. Yeah, it's interesting that most of these terms, these caveat emptor and all this sort of stuff, they are very, very old in their usage, but they still prevail today, and quite internationally as well.
Well, the thing is that these, a lot of commercial law literally goes back to the Phoenicians, because they were the sort of first international, well, not the first international traders, because it's been going on before that, but the first people to actually establish a code of laws. And it's rather strange that because ultimately people had a long time ago worked out what the rules should be about who should pay for what, who is, if you order a load of goods, and it's delivered by ship and the ship sinks, who takes the loss? Is it the seller
Yeah.
or the buyer? This was all sorted out sort of 4,000, 3,500.
Yeah, long time ago, because, and then you get the terms like, free on board or whatever. So there is literally a difference in the contract, which you'll learn very, very quickly if it goes wrong. The difference between the two. If you've got a difference between who is at risk of the money for the value of the goods, there's basically two scenarios. You as the buyer are at risk as soon as it leaves the origin, or the other way around. You're not at risk until it reaches you. And it's a very big distinction, because, as Al just said, if the ship sinks, then, well, the contract will determine who's responsible. You either get your money back or you don't. And it is normally that simple.
In art law, in the art field, we actually call this nail-to-nail insurance, because basically it's from when it's lifted off a hook in one place and until it's on a hook in another place, the insurer is liable. So that's
interesting. That's interesting. Literally, so until it's hanging in the new place, it's at the
and
risk.
If you get to this, what happens if you're hanging it and you drop it? What if the nail's not in properly? Again, this crops up in like we've just been talking about international law.
Yeah.
Generally speaking, in England and Wales, the limitation period for personal injury is 3 years. However, if it takes place, the accident injury is on a ship or an aeroplane, it's only 2 years. And there have been cases where people have either slipped on gangplanks or fallen down the steps on aeroplanes.
On an airplane.
Like, what's
So
the
are
limitation? Where was the damage? Was it when they tripped, or was it when they hit the tarmac?
Yeah,
Because
so are they on the so are they on the plane whilst they're on the stairs getting off the plane? They're outside of the carriage, but they're still on the stairs that are connected to the airplane. Interesting.
It's until you set foot on the quayside or the tarmac, you are still within the 2-year limitation.
You're still on the plane, right? And there's also limitation by knowledge as well, if you're not aware that there's a certain injury. So some of the old asbestos claims where people didn't know that they had this injury developing in their lungs for many, many years, 30, 40 years later, and then what caused it. The limitation would obviously otherwise have been long gone, but the laws now say, well, no, that's not fair. It's just a new thing, so it's date from knowledge in certain instances. Interesting question popped up earlier that I favorited because I wanted to come back to it. Can you ask a fellow juror to say a person is guilty but not to sentence? I presume you mean that you're saying they're guilty but not to give them a sentence. And I don't know if this is linked to the Alex Belfield case, because it came around with the other comments to do with Alex Belfield. Obviously, this is not, just in case it was, it's not a comment in relation to that. But I know Al's desperate to say something, but in short, no, it's the sentence is down to the judge. Go on, Al, what are you going to say?
I actually had this in a case. Now, one of the weirdest things is before I went off and had a really happy time doing certain things for News International, doing the night lawyering, I was actually in a case where it was one of those Mazhar Mahmood fake shake cases, and we were acting for I was trying to find the reports about it because it actually obviously got in all the papers. But that was one of these where he basically did a sting operation to effectively coerce people into saying, yes, I can get you some drugs. And when the tactics came out, the jury were clearly disgusted, although the judge said, as a matter of law, all you have to show is they basically said, yes, we will arrange to get you some drugs, because then it was called being concerned. They didn't even have to supply them. But the jury literally sent a note saying, although the judge has said we have to find these people guilty, we don't think it's fair, and they were set up. But the judge says, yes, they're technically guilty, but we don't think they should be. And the judge basically said, okay, I'm going to take that into account, even though normally the sentence for this offence is sort of 3 to 4 years. I'm going to give you a non-custodial disposal. For the next live stream, I'll try and find all that and just check.
Yeah, that'll be interesting. I mean, the strict answer is no, because the sentence is down to the judge. It's literally a finding of fact, and it's guilty or not guilty, or we can't decide. Those are the only 3 options. And a lot of people often think it's 2 options open to a jury, and it's not. There's 3. There's the third one, which is we cannot agree, and even given enough time, we cannot agree. That's a hung jury, trial over, but no verdict. It is open to the prosecution to bring the case again. They sometimes will bring the case again, but probably not usually not for a third time. So yeah, but no, that's interesting. The judge can, of course, take anything he or she wants to into account, and that's why, for those of you that are wondering, particularly you might be wondering in the case of Alex Belfield, this is not comment in relation to his case specifically, but if you are wondering generally, the judge will usually want to have as much information as possible and take time to think about it, and maybe reports, all sorts of other stuff, and then representations, mitigation, and so on and so forth. So I'm going to refrain from making any comment until after that point, but that's generally what the case is. The judge can take any of that into account and make a decision. And as Al said, it can just be, this is ordinarily custodial, but in this case it won't be. It is open to the prosecution to appeal sentence in that case if it's non-custodial. When it's normally custodial, it's relatively rare, but it does happen. Again, I'm presuming that there is an equivalent of sorts in most international jurisdictions. The way that they work will differ slightly, but hey, we're not going into so much detail anyway. But hopefully that's useful. But also circling back, bankruptcy is another thing. Al, you touched on it very briefly earlier, whether or not bankruptcy affects judgments. And again, there's this distinction which is somewhat similar with insurance, which is that, well, there's the element of intent. And, certainly in England and Wales, judgments are usually wiped out as a standard, but there are exceptions, and there are certain things that you can't exclude and escape in a bankruptcy. So I had one case. Obviously, I cannot. Well, I wouldn't anyway. But there'd be no need to disclose details. But I had one case with a family matter where somebody wanted to. I'm careful how I say it, but essentially, someone wanted to escape the child maintenance payments. That's all I can say by way of a bankruptcy, and that was the whole strategy throughout the case. But you can't escape child maintenance payments. The courts and the law takes the view, no, they're your children. You're responsible for your children. You can't just say, well, hey, I've accrued so much debt I can't pay for it, therefore I shouldn't have to pay for my children anymore. The law doesn't agree with that. The law says, no, you will continue to pay for your children. This is the way that it is. There's certain things that you can't escape. I don't think you were quite finished on that subject of bankruptcy before we moved on, Al, but Muggy,
no,
I'm live.
I think you've covered it. Like I say, it's all going to turn down to this. Was it intentional or malicious? And the interesting thing is, how do they assess that? And theoretically, the insolvency court can have a hearing, but an insolvency court isn't going to want to have a full trial on the facts on this. And if they can't infer it from just the documents, I suspect that might be the tension. There will be. Do we waste time looking at this, or do we just say, no, we'll just do it on the face? But does that deprive somebody of their legitimate damages? So that's an issue. But also, Dan, I have just sent you in our messaging thing, I found the report from the case. So to go back to whoever raised that very interesting question, and I'll let Dan read it out because he's got better eyesight.
I was going to PDF it and bring it on screen, but you probably won't read it anywhere, so I'll just read it out. This bit... In delivering their verdict, the jurors said that the law being different would have cleared the two men of the extreme provocation from the reporters. The judge ruled that the 2 years received and the 15 months given would both be suspended for 2 years. But he said that had it not been for the jury's plea and the way the men were entrapped, they would have been looking at up to 4 years in jail. That is really interesting because... It just goes to show that it's not just about sort of black letter law as such, is it? So in a case generally where there is a sort of common public interest that certain things should not ordinarily be criminal and certainly shouldn't be, punished by a custodial sentence, even though perhaps the law says in certain situations they would be. All of the circumstances can be brought together, and the judge can say, well, I've taken everything into account and I'm not going to impose a custodial sentence in this case. And that does happen, and that's one such interesting case.
Yeah, I mean, just a jury can always acquit in any circumstances, even if the judge directs them to convict. They've always had that power. It's what we call a perverse verdict, but we are not allowed to tell jurors that. And in the States, they have the same thing. They have a simple rule, jury nullification, they call it, and it's an offence. It's a disciplinary offence to sort of raise that with juries. Yeah, and stuff. But you do see people like outside courts handing out leaflets.
Yeah, and it's actually it's a really interesting point, which I'm going to pause for suspense just for a moment while I say that Vilo asked the dear wife on Easy Chinese Cooking, which if you aren't subscribed already, you must absolutely go and subscribe. We are just about to get that channel up to 4,000 watch hours. If you know, you know. If you don't worry. Can you make a video on red barbecue sauce, please? And my lovely wife replied and said, I've got a few barbecue sauces coming up. Thank you for support. So please do support. I'm very supportive of my dear wife, and I thank you for your time in allowing me to do so. The link is in the description, and I'm sure Secret McSquirrel is filling it in the chat box below. Please do go and subscribe there. And so I was just about to continue on that jury nullification. Yes, it's a really popular request, about almost to the point of a conspiracy theory that you're not allowed to talk about it, that we are not allowed to talk about it. We work for the system and we can't talk about jury nullification and this sort of. Well, yeah, it's actually, as Al said, it would be an offence for us to do so to a jury that we know is deliberating on a case. I mean, generally speaking, as a standard topic to discuss, no, because it's just, well, it is what it is. It's a well-known phenomenon that juries sometimes say, no, we don't think he's guilty, even though the law says he is and the judge has directed us to return a guilty verdict. We don't think he's guilty, and they do that sometimes. And that they might make their feelings known by saying exactly as much. But as Al said, we cannot offer to the jury. You do have the option to say, not guilty, even if you believe the law says that he's guilty. We can't do that.
I've just sent you an image. I don't know if you can bring it up on the screen now.
Yeah,
but the irony is, in the Old Bailey, there is literally a plaque commemorating the jury that established this principle. So and the trouble is that you sort of hope that might be a plaque that the jury won't.
Yeah,
and I
just
can
be
give
a
a little bit
moment
of
to
detail
bring that on, but I will be able to bring it on. But just bear with me a moment.
Okay.
Let me open a browser. Not Grammarly. Carry on now. I'll bring it up in a second.
Well, what I'll do is, I'm going to try and top and tail this I'm going to try and be really clever here to tie it back to something, because this all arises out of a case that's actually we call it Bushell's case, although the trial was Crown and Penn and Mead. That's including Penn, who went off to found Pennsylvania. And they were preaching in the street at a time when it wasn't allowed. There's also, Dan, there's a little picture of I've sent you a blow-up of the actual plaque for effectively rabble-rousing. And what was interesting is the jury said, well, we're not willing to do that. We're happy to say, as a matter of fact, they were preaching, but we're not going to say that you were rabble-rousing, that they were rabble-rousing, so we won't do it. So the judge basically, he said, right, you're staying in that jury room without, and I think the phrase is like, without heat, fire, warmth, water, or sustenance. Basically, you're staying in that jury room with the fire off and nothing to eat or drink until you come back with a guilty verdict. And they basically said, right, we're staying here. And it all went off to that higher authorities. And in the end, they came back, and like I said, this is the plaque where they said, look, juries, the whole point of entrusting cases to juries is they are the final arbiters of justice. You know, the light that shows for freedom burns and all that sort of thing, to use another phrase. And this is, you know, it ties back to the importance of juries. We've had a lot of discussion recently about judges and juries. And while obviously Dan and I have huge respect for the judiciary, you know, we genuinely do. That's not to say that there isn't a role for the jury. And also, I think people recognise that when it comes to findings of fact and findings of where should be the boundaries of the law, perhaps the best people to settle that are jurors. And this plaque commemorates that. But what was very interesting, to tie it all back into it, of course, when the jury were out in that trial, there was a big thing about the fact that they no longer got lunch on the court. They had to bring, basically the judge wasn't, and there was lots of discussion as to why that was happening.
Yeah.
And, you know, was it a budgetary thing? Was it just a practical thing? Look, if they just want to, we just want to leave them in a room to get on with it, and they can bring sandwiches, you know, rather than dragging them out for lunch all the time. If they don't, we just leave them. Although we did jokingly suggest, and you know, is the judge trying to pull a Pen and Mead on them and basically saying, you're not getting, we've been here for 7 weeks, you are not getting fed until you come back with a verdict, so hurry up about it.
Yeah, absolutely. It's just fascinating, isn't it? I mean, this is what draws a lot of us to law, because there is so much history in the law that prevails today and internationally, because as Andrea Burkhart recently said in one of our videos, I remember the phrase that, you know, we're sort of cousins in law, and you know, pun intended. And a lot of the principles are borrowed, pinched, stolen, manipulated, and prevail. And they are used internationally. So it is very interesting to look back at some of these and see how that certain parts of them still creep in today. Absolutely.
Yeah. Well, we know because it's our friend Lady Mentat. She might not be on here, but if she watches this later, because she, like a lot of people, like all that sort of history of the law. And it's not just interesting from like a nerdy trivia point, which I like. It's also, it shows how the law has evolved to where we are today. And like I say, this all comes back, and Bushell's case is all about the power of the jury.
Absolutely. Did we finish up with bankruptcy? I think we pretty much did, didn't we? What else? We've talked some about insurance. We've talked some about bankruptcy. We've talked about the punitive damages. We've talked about default judgment. So
yeah,
we've talked about most of what the thumbnail promised. It's not clickbait, I promise you. Some people say this is clickbait. No, it's designed to make you click it, because that's why we're here. Otherwise, we'd be here talking to ourselves. But it's only clickbait if we don't talk about what's in the thumbnail. And we do.
We should do this. When judges sort of like, you know, give judgments, they should say, I'm dismissing your appeal on 10 separate grounds. Number 7 will astound you.
Yeah. I'm dismissing your appeal on the grounds that I don't like it.
Yes. That's not an uncommon one.
Yeah.
Yeah, I've said that. So, may it please the court. I assure you, it doesn't. That was the response.
Yeah, I know. I've heard that before. And then the other one, when you are literally in the wrong court. I've told this story before. This is the very short version. You know, normally you stand up and I appear for insert name of the party that you appear for. In the case that it's wrong, as told the story to me by a Silk friend of ours, Silk being Queen's Counsel, I appear to be in the wrong court. It's just classic. And actually, on the subject of juries, I think I've told this one before as well, but some of you might not have heard it, so I'm going to tell it again. But we obviously have guilty, not guilty, or no, we haven't reached a verdict upon which either we've all agreed or so many are agreed. But in this one particular case, everyone is sat around with the jury in, obviously. And there was, I think it was 14 counts, and there was what we call a multi-handed case. So there's more than one defendant. There's about 5 defendants in this case, but there's about 14 different counts going on and on. And so they're reading through them, And at each count, all the jury were looking at each other as if to confer, and then the foreperson would say not guilty, but they didn't quite look sure, as they're supposed to be sure, obviously, because that's the legal phrasing these days, beyond a reasonable doubt, so that the jury are sure of the verdict that they give. The judge said, I have to inquire, because it's been noticed in the courtroom that you don't appear to be sure of the verdict. Are you sure that this is a, not guilty, and so on? And then they said, well, we just haven't decided. And at that point, it became clear that on every verdict that they'd said not guilty, there were one or two guilties, but on all the ones that they said not guilty, they just weren't sure. And so the judge said, may I just clarify, you said not guilty, but actually you are not sure. Does that go for every time that you said not guilty? And I think they qualified one and said, no, that one is definitely not guilty, but the others we've said not guilty because we're not sure. So we had this whole conversation about, well, actually the judge sent them out first to discuss with the lawyers, like, how do you want me to deal with this? This is one of those scenarios where the books that I've showed you there, that stack high, that tell us how we're supposed to deal with these things. Sometimes in these books, there's one thing that says, if this happens, we haven't bothered telling you what you do about it because it's not going to happen. But obviously, when it does happen, the book tells you nothing. And so the judge and everybody around the court was saying, well, what do you want us to do about this? Let's bring them in and tell them what they're supposed to do and send them back out to re-deliberate. And everyone was happy with that. It went down. So the point of it going down and everyone appealed, the point of it going down and everyone agreeing, by the way, is so that there's no point of appeal. Because if someone didn't agree, there's a point of appeal. There's very often a point of appeal. I'm going to answer this question just because I want to. Maxine, no, we don't shave our heads just to accommodate the wig. We shave our heads because we don't want the stubble, because we don't want to be thin on top. I think I can speak for Al when I say that. That's why.
I literally do it because I'm really lazy, and it's the most convenient thing. Like, take 2 bottles in the shower. I just basically just go and shave it off.
Yeah.
And also, I like to pretend it's because you've got black belt barrister. I wonder if I should go for Krav Maga counsel. But I used to do all the.
Oh, there. In the comment, please, in the comments box, if yes or no, Krav Maga counsel, I think that should be a thing. Alongside our
going, no, stop it, you are not exactly the example we want out there. But in all fairness, in the martial arts especially in Krav, there's a lot of hair grabbing, it does actually, it does exist. And also, just generally when you're grappling, it's a good idea to be very, very slippy and
absolutely, yeah. Greasing the hair was one of the first things told to Marines and Special Forces, because they can't grab your hair. Well, they don't have that problem with me anyway, so thank you, Andrew, for your kind super chat. When AH inevitably, I see that you put loses her appeal, is there a higher authority that she can appeal to, or will it truly be final? Well, my understanding is from that point it is final. She can go to the superior court, but that is it. And it's only on those narrow grounds, and only if she posts the bond, and then only if she produces the evidence. And it's not, well, I say evidence, the filings, the documents upon which they rely in the appeal, but it's not a full rehearing, it's not a full trial, or all that sort of stuff. But that is it as far as I'm concerned. Al, I think that's your understanding, and uncivil law, excuse me, pun unintended. If you're still in the chat, maybe you can clarify that as well. I'm sure that is the case.
My understanding, because you've got an appeal as of right. In Virginia, you've got an appeal as of right to the appeal court, although, like I say, it's all this done on the papers, and if they allow you a hearing, it's usually like 15 minutes aside. If you're unsuccessful on appeal, theoretically, you can take it to the next level, but that court pretty much gets to select its own docket. And, and even if it says, well, yes, you have some grounds of appeal there, but unless this is of a matter of wider public interest, something that affects more than just you, like, clarifying the area of law that, has general applicability, we're probably not going to entertain it. So effectively, no doubt there will be, if this appeal is unsuccessful, there will no doubt be an attempt to take it to the next level, but that might well be, and subject to how the appeal court, if the appeal court say, we dismiss all these grounds and find them totally without merit, that again would make it very, very hard to appeal. But, we don't know yet. We'll have to wait to find out.
Indeed. I think uncivil law's still in the chat, so if there's a comment there, I'll bring that on screen as well. No, actually, moving back on the martial arts scene again, you're not allowed to. It's just some people do. Krav Maga, is that a rule that I did?
Well, because Krav Maga is not a martial art; it's a self-defense system. So there are no, it's the old thing that there are no rules.
I suppose it is. Yeah.
We said you want to learn this Krav Maga syllabus.
Yeah, I mean when you're training, but obviously in out in the wild, as it were.
Yeah. But get the USC list of FAQS, and that's pretty much the Krav Maga syllabus. Yeah. But yeah, there is a lot of hair grabbing and defenses, and how to do it properly. You sort of shoot your fingers in there, and and then grab and pull, and then there's all the defenses against it. But you can eliminate a couple of pages of the syllabus merely by shaving your head.
Yeah, absolutely, and that's obviously a very good reason for doing it. That's one of the first reasons I did it. Way. Before it may not have grown back in the full glory that it once was, but there we go. There we go. Answer from Uncivil Law. Thank you very much. AH could request a further appeal to the Supreme Court of Virginia, but that's discretionary. Yeah, I thought as much. So it's their discretion, not hers. If you're not already subscribed, by the way, and congratulations once again to Uncivil Law for the surpassing 100,000 subscribers. It is such a feat, and believe me, it takes a lot of effort. I've been toiling away with my dear wife and her easy Chinese cooking channel, which I'm plugging once again. It was 11,000 or something 11,000 subscribers now or thereabouts. It takes a lot of time, a lot of effort, and years normally to do that. So huge congrats to Uncivil Law. Well deserved, and it certainly doesn't come easy. But thank you also to Secret McSquirrel. You really, really are everywhere and assisting us. So I'm really, really grateful to that. I'll bring this on again from Uncivil Law. She has an argument on a question of first impression, namely it's possible under Virginia law to defame a public figure by implication. Yes. Virginia has said yes, generally, but never directly answered the specific question. Yes, that's my understanding as well. So very, very useful comment there. Thank you very much for that. We should bring you on at some point when I get all my my scenes set up so that I can name you. I'm not quite as quick-handed as Andy Signor at Popcorn Planet yet at naming all of the scenes. I've got to pre-do them first, but we will bring you on at some point. Thank you, Leeds, for saying that my dear wife's Chinese cooking channel is an excellent cooking channel. Did I mention my dear wife's got a Chinese cooking channel called Easy Chinese Cooking? Yes, I did. So I think we covered everything, did we, Al? That we wanted to do. Unless there's any sort of closing comments you wanted to make, we're just over the hour. I think that's a nice rounded sort of time. I will bring a follow-up from Uncivil Law. I'll bring that up. Some states have a split on the issue of defamation by implication as to public and non-public figures. That's a very interesting point. So Virginia could do that as well, but it's up to them. Don't think they will. That
is an issue, yeah, because actually Uncivil Laws actually covered this really well, and so has Civil Law. And this is the one thing that we seem to be of the opinion that theoretically is a potential ground because it's an issue that hasn't yet been decided. Now, whether or not the appeal court will use this case as the opportunity, my gut feeling is that if they're going to do that, they will do it on a case where it makes no difference, where it's like you would have won the appeal anyway or lost the appeal anyway, but we'll use this opportunity to make the decisive decision one way or the other. It's a bit like the Banks and Cadwallader case where for a long time, we were arguing about what a particular thing meant. And they said, this is possibly the case to decide that in. And also recently we had that malicious falsehood case where they finally, after a mere 70 years after introducing the Act, they finally addressed what Section 3 actually meant and what the test was. But it doesn't mean, just because an area of law is unsettled, doesn't necessarily mean the appeal court will seize the first opportunity to settle it. They might say, well, actually, we'll wait for a case that's more general applicability and we can address it in more detail and it becomes more generally applicable. Because it's a big thing when you're trying to sort of argue law, you'll always try and distinguish your case from a previous case that seems to go against you. So you say, oh, the Court of Appeal said this. Ah, yes, but in that case, the car was blue, and in our case, the car is red, something. But it's the legal equivalent of doing that. So they tend to save points for this, for where they can give a definitive ruling that will be more generally applicable just on a rather narrow ground that only applies to one particular factual situation in one particular case. So, yeah, I think the general consensus is it's not bad ground. It is something the court at some stage will probably want to address, but we don't think this is the case they will address it.
Absolutely. Just typing a comment here. I've actually just said, let me just, a couple of things before we wrap up then. Lady Decade from your super chat earlier, don't forget to contact me if you haven't already. I did put my email on there. It's easy. It's just contact@blackbeltbarrister.com. One commenter once said, you're hiding yourself. I'm like, no, I'm not. My name is literally all over YouTube, Google, everywhere. You just Google my name and it comes up. And you can find me. It's literally contact@blackbeltbarrister.com. And as for your comment, ZYX ... if that is your real name, will Alex Belfield get a chance to appeal? Well, any appeal from the Crown Court on conviction and or sentence will require permission. And if you appeal the conviction, then sentence is at large, meaning if you've been sentenced, then the appeal court can change that sentence. But you need permission. So it will need to be an application for permission to appeal, and the grounds of appeal will be set out, and there is a time frame. And that's all I can say without giving any further comment, because I can't. But in answer to someone else's question, do I work for him? No, I don't. I'm happy to answer that. I do not. I will probably give some comments at some stage, but I'm not going to do that now. And civil law, I think I saw another comment for you just before we leave. Alan is referring to the concept of a case being a good vehicle for a court to decide an issue. The highest court typically only answers novel questions, novel being new or something that hasn't really been dealt with before, in a clean case that avoids other complexities. That's a very, very good point, actually, because these are what we call test cases. So, and this is a universal concept. It's not to England and Wales. A test case is, we haven't really had this issue before, i.e. this problem that the court needs to decide on before. So that becomes a test case. If the court, particularly if it's it can be a county court. I'll come back to that in a moment. Remind me of Ring Doorbell if I forget what it is, Al. But it can be a county court, but it's more usually a high court or an appeal court or a superior court or a supreme court or whatever. It's usually one of the higher courts when they say, we've got this issue, we've not dealt with it before, let's decide it now so that any future cases are much simpler. If this happens in that way, this is the answer. And this is an important point here, because that is describing the case being a good vehicle for the court to decide this issue. But the important point here is that it has to avoid other complexities, because if it's, well, here's the question, but X, Y, and Z at the same time, then naturally you've got to consider those together, because the court will almost always consider all of the circumstances, because how could it not? Unless there's a specific rule or a law that says do not take that into account. Then, for example, inadmissible evidence, and it's like, well, that shouldn't have been in evidence, so disregard it. So it would disregard it. But if things are considered, then it's not really, it can still be a test case, but it's not a sort of a paradigm test case, because it's not just that issue that they're deciding on, it's that plus XYZ. So then any new case would have to be that issue plus XYZ. And if it doesn't have X, Y, and or Z, then it's difficult to decide that. So I think that's a very, very intelligent point to make there. Ring doorbell case.
Ring doorbell. County court.
So county court judgments, this is like the standard sort of, I say bottom rung, but don't be under any illusions that this can't be a significant judgment. It can be just, it could be whatever the court says the judgment is, but it's the first rung on the ladder for the courts in England and Wales. So whilst they are not strictly completely binding on themselves, they are usually very influential. But again, it comes back to this sort of paradigm test. Is it a definitive question, or is it plus X, Y, Z, as I just said? Now, the Ring doorbell case with CCTV, data protection, harassment, and there was a whole few issues together. A lot of people suddenly panicked and thought that you suddenly have to take down. I've done a full video on it, by the way. I don't know if Secret McSquirrel can find it and link it, but if you just look at Ring doorbell in my video library, you'll find it. But it was essentially this. There's some guy had got loads of cameras watching his neighbor, essentially. And the court found that it was at least in part, there was a breach of data protection. There was some, harassment issues to talk about within the case because it was recording audio. He'd made threats to send it to the police, to report it to the police. And the court found, as a question of fact, that he had not done that. So it was only done to intimidate the neighbour, to say, aha, I've sent this to the police, I'm going to report you for a crime, when he actually hadn't done so. So a lot of people panicked and thought that they had to suddenly take down their Ring doorbell cameras and all this sort of stuff, which is obviously not the case. I did a very lengthy, in-depth video about that judgment. The point of me saying all of this is, that was essentially a test case, but it was at the county court, i.e. the bottom rung level. And I think if that really is, you are super amazing. And actually, then so is my dear wife, because they both found it. It's in the description. Look at that. Look, literally, both one after another. Look how great that is. Both have put exactly the same link in the chat box for you. So it's a fantastic judgment to look at. It's really interesting because it's this whole idea of a test case where it was going to come up. And watch this space. I guarantee you at some point it's going to go to court where someone's out with a drone, where the police are saying, take that down. And let's be clear about it. The police have got no jurisdiction to tell someone flying a drone to take it down if they're flying it within the rules. But then you've got the obvious difficulty of, well, you should do what the police tell you to do. But if the police tell you to do something that you shouldn't do, then that's, abuse of power. But that's a different question. And so, as I said, watch this space. That will go to court. And whilst we're on that tangent, many auditors have recently, and I've had several emails about the same question, saying, can the police demand the operator ID, which is essentially like a registration ID that you must put on the drone? Must you give that to the police officer? Now, I can't find anywhere in law that says that you must, but if you don't, it's going to give the police some ground to suspect that you might be involved in terrorism and therefore use the detention and search on that basis. Just give it to the officer if you've got nothing to hide. It's not going to suddenly make you guilty of anything, even if they find out who you are. Big deal. They have to have a reason to find out who you are, i.e. they've got to suspect you of doing something wrong to find out your details from the details on the operator ID. Otherwise, again, it's an abuse of power. Just like your vehicle registration. They can call it back to see if it's on record, but they can't suddenly just go and get your name and address unless they actually suspect that you've done something wrong, unless it's a 163 stop under the Road Traffic Act. But we digress. So maybe another video on that shortly. And with that, I think I'm out of tangents. Anything else before we wrap up, Al?
No, I was thinking about a million tangents as we were going, but yeah, it's probably before this becomes like infinite stream of consciousness. Although some, And one thing we'll have to do one day, because as it happens, among my many nerdy things, I'm a bit of a Titanic nerd, especially the legal consequences of the inquiries. And somebody raised maybe one day, maybe on the maybe on my Arty channel, we'll do a Titanic thing, the legal issues from the Titanic, because they can be quite fascinating. But to get back to the topic at hand, which I know is not really my skill set, but no, I think we've covered everything. We've hopefully underpromised and at least delivered. So yeah, I hope people found that useful. And like I say, it's all the celebrity stuff. But yeah, things like this do affect you in real life. Judgment in default, especially for failing to comply with like timetables, is something that affects real people. What you can get on your insurance policy for legal expenses, and of course insolvency. So yeah, hopefully we've answered some of your questions, both in terms of pop culture and legally.
I think we've certainly delivered on the thumbnail. I will, because Secret Monk Squirrel is so very helpful. Again, thanks so much to you and from everyone in the chat, I'm sure. But just to follow up on your question here, but the police want the video of it if something happens near your house. There's a narrow exception in law that allows them to do that, because if a crime has taken place, or they've got grounds, good grounds to suspect that a crime has taken place and that there's some evidence that they can uncover by demanding it from you, there is a narrow exception within the law that allows them to do that. What they can't do is insist that you delete it. They can't insist of a copy of it just because they want to, because they've seen you doing it and they're like, hey, you're filming, we want a copy of it. By itself and without more, that's not good enough. They can't do that. I don't support, let's just be clear before I say any more about this. Let's just be clear. I don't support antagonizing people for the sake of it. I don't support the idea of going to wind someone up just to generate views and that kind of stuff. There are some ways of doing it, but if there is a retaliation and it's on film, almost fair enough, but it's got to be within reason. But if the police want the footage, as this comment just suggests, there's got to be a reason for it. They cannot just demand a copy of it just because they want it. There's got to be a reason, and it's usually there's a crime taking place and they suspect that there's a comment, Warberman, I've seen your comment. I'm not going to bring it on screen because of the language, but if they spout some law, etc., they can't just, it works both ways. If the person doing the filming actually knows the law and it's correct, they can say what the law is. If I was out filming, right? If I was out filming myself, welcome back to the channel and so on, and someone behind me said, hey, I'm in the background of your video, I don't like that, you've got to delete it. And there was a police officer walking by and they say, officer, he's got me on his camera. I don't like it. I want him to delete it. And the officer comes along and says, hey, you've got to delete that. I would say, well, actually, respectfully, no, I don't. There's nothing in the law that requires me to delete this footage. If there's some real significant reason why you want me to delete it, I'm happy to listen to it. But otherwise, generally, you're incidentally included in the background. We're in public. It's a public place, blah, blah, blah. I'm not obliged to delete it. I would do that politely, respectfully, trying to avoid arguments. And if I could just refilm what I'd just done, I'd probably agree to delete it. It depends what it was. If I just captured the best footage of the last flight of a military aircraft that's ever going to fly, and someone on the ground said, hey, I want you to delete that footage, I'd say no, because I'm never going to get that footage again. And just because you're in it isn't a good enough reason to ask me to delete it. You can't make me delete it. A court could, but a court won't, because there's no reason to. Again, without more. I hope that answers some of the questions. I've done loads of videos on this. Check them out in my video library if you find any of that of interest whatsoever. But otherwise, I thank you all for your time and patience, especially to thank my sponsor and for plugging my dear wife's channel, Easy Chinese Cooking, which is linked in the description below. And Al, thank you for your time as well. Much appreciated, as always. I'm sure it is by everybody in the chat. Big hand for Al for joining us, please, everybody. I'm very grateful. I'm sure you are too. And thank you for your time on this Sunday. It's been an hour and a half. I've been the Black Belt Barrister. We've had Alan Robert Shaw, Esquire. Thank you very much and have a great Sunday.